Hi, everybody. Welcome to Trial Alchemy. I'm your podcast host, Monty McIntyre. I've been a California civil trial lawyer a couple of years since 1980, and a member of the American Board of Trial Advocates since 1995. Most of my career, I was a civil trial lawyer, and I represented plaintiffs and defendants in cases like torts, business, real property, insurance bad faith, employment cases. These days, I help lawyers get excellent results three ways. First, as a mediator, I help them settle cases. I decide cases as an arbitrator and decide issues as a referee, and I do this with ADR services. Second, I make it easy for lawyers and law firms to always know the new case law in their practice areas with my online publication, California Case Summaries, which publishes one paragraph summaries of every new California civil case. And last, I help lawyers become better jury trial lawyers with this podcast, where I interview outstanding plaintiff lawyers, defense lawyers, and civil trial judges who are members of ABOTA. And we talk about what works and what doesn't work in jury trials. And I also help mentor lawyers to learn to become good jury trial lawyers. Now, Trial Alchemy is brought to you by California Case Summaries, which helps lawyers save time, know more, and win more. And if you do a one private half day or full day mediation with me, you can get a 1 year individual attorney subscription. Only that attorney can read the summaries, but it's a $1,999 annual value. And for law firms who'd like to get a law firm unlimited subscription where you can give summaries to everybody in the firm, if there are two full day or half day private mediations with me from lawyers at the firm, you get a 1 year free subscription, which is a $6,500 value. Now, today I'm delighted to have as my guest on Trial Alchemy, Richard Schoenberger. He goes by Rich. And Rich is a remarkable lawyer. He's a great guy, great sense of humor, but he's had tremendous success in his almost 40-year legal career. His success and presence in the courtroom has made him one of the most highly respected trial lawyers in California. And Rich was inducted in 2024 as a 37th member of the California Lawyers Association Lawyers Hall of Fame. At various times in his career, Rich has held or shared the record for the largest verdict in different kinds of cases in places like San Francisco, Sacramento, Santa Clara, San Luis Obispo, San Mateo, and Sonoma counties. In September of 2025, as an example, he obtained a $26,300,000 verdict for a young man who was his client who was paralyzed after the roll cage of his Yamaha YXZ side by side collapsed in a rollover. And this is one of the largest verdicts ever handed down in Orange County. Rich has tried or settled well over 100 cases for $1 million or more, including in the last few years. As an example, he's resolved individual cases for 50 million, 25 million, 23.3, 19, 18.5 million. And he recently had a record $24.5 million recovery that's considered one of the largest settlements of a medical malpractice case in California history. He also received the Don Bailey Award from the San Francisco ABOTA Chapter, which recognizes someone who exemplifies civility, professionalism, and integrity in the practice, while also vigorously and courageously and expertly advocating for his clients. Now, Rich, because of this great record, is an invited member of the most prestigious trial organizations in the country, including the International Academy of Trial Lawyers, the American College of Trial Lawyers, the International Society of Barristers, and also ABOTA, the American Board of Trial Advocates. And Rich served as the president of the San Francisco chapter in 2014 during its 50th anniversary year, which was a great time to serve. So thanks for being a guest today, Rich. I'm delighted to have you on. Thanks for being here.
Oh, it's my pleasure, but keep going. It's not over. No, I'm kidding. That is, I fell asleep 2 minutes ago. The idea that you would invite me is it's a real honor, and I mean that because I've seen your program before. I love what you've done with respect to your summaries of the appellate court cases, which is really helpful. And so thank you. You said to me you're trying to get the viewership down, and so you asked me to come along, and so I'm very happy to oblige.
Well, I don't think you're going to accomplish that today, Rich. It's still going to be a lot of interest, and thanks for being here. So let's start off with this. We're going to talk today about trying cases, but you've tried so many cases, but what would be an example of a great satisfying trial victory that you've had? Could be recent or could be further in the past.
I think that it's in some ways first and last, if I can. In the early
Sure.
90s, because I had been a deputy DA and um, I guess I considered myself sort of fearless about trying cases. I was one of the few deputy DAs who actually lost cases because, the DAs can kind of set them up and try what they want to try. And
Right.
um, but I was with Alameda County, and I tried cases that I believed in and that other people didn't want to try. And some of them were really hard, especially in front of an Alameda County jury. And then when I got the privilege of going to walk up, there was this case that, I was like 31 or 2, and it was this big publicity case called the 911 case involving Scott Quackenbush, who died after a Giants game. And we actually lost the summary judgment against the city because he called 911 and they gave it a low priority. And they said, the court, that there was no duty. And as a result
Hmm.
of losing that, our only defendant was the tow truck company who had dropped him off at a closed gas station because his car had broken down and he'd been towed. He was a 19-year-old kid. He weighed about 120 pounds. He had this sort of cherry uh, uh, Mustang that he just loved. But, it had broken down. He was a sophomore at Weber State in Utah. And uh, when he disappeared, it turned out that he'd been dropped off in a parking lot that was sort of Tongan turf war. There was a Tongan community, and before they would go
Wow.
to this bar across the street, they would gather and drink in this parking lot. And at about 11:30 at night, this idiot tow truck driver drops him off and then leaves. And the he's scared and he calls 911, and in 911 call you can hear him being approached and sort of pummeled a little bit, and that's why the case against the city we thought was compelling, but legally it wasn't. He disappeared, and his father found him 3 days later after a massive community sort of manhunt. In fact, he was found over the fence from the gas station, having died from fight or flight syndrome.
Oh my
He,
goodness.
some kids punched him, but none of them were fatal blows. He aspirated on his own vomit from fear, and that's how he died. And they were uh, they were prosecuted They were prosecuted by the same prosecutor who prosecuted Dan White, I would say unsuccessfully.
Hmm.
Um, and they were convicted of involuntary manslaughter. And I remember in the motions in limine in the civil case, Frank Kelly and Bob Luft, both amazing trial lawyers in their own right. Frank's still with us. Bob sadly died some years ago. Um, they kept calling these guys murderers because they wanted the percentages of fault. There were no economic damages to go 100% to them. And I moved in limine that they couldn't call them murderers. They could call them involuntary manslaughterers because they weren't murderers. It was a homicide, but they weren't
Yeah.
murderers. And that trial was so intense because it was above my pay grade. I wanted to try anything. And there were partners at the firm who kind of didn't seem to want to try it, and I jumped in on it. Um, and it was during a time when our first, Monica, my wife, and our first, Monica was pregnant with Alex. And I remember doing a closing argument, and Monica was there watching. And I didn't understand what it was like to have a child then. Um, I would soon learn what it was like to have a child, but
Yes.
I didn't, to me, it was a little bit like a priest giving marital advice. I wasn't,
Yeah.
I wasn't quite there, but I do remember in that closing argument saying, you know, we all talk about the milestones where we'll be there. We'll be there for graduation. We'll be there for the baptisms of grandkids, and we'll be there for first jobs. But mostly, what we are is just there. It's the times outside of those that mean so much. And Bill Quackenbush, this was his middle child, was so devoted, not just to his son, but to doing justice in that case. Such a sweet, honorable, gentle man. And we got a verdict, and it was a big verdict for that time, but huge percentage went, I mean, it was a no offer case, but a huge percentage of fault went to the people who killed
Right.
Scott, as it should have. I think that this is what I remember. It was $1 million verdict and 25% against the tow truck company. We went around and polled, and it was 8-4. And the jury had been out for like 5 days.
Wow.
And so they had to go back, and one of those jurors went and threw up in the bathroom. It was so intense. The tension that the jury experienced was so high, and they came back. So $1 million and 10% was, or 25% was a $250,000 verdict, which was about the mid-range of what verdicts were, and the million was way above what a wrongful death for a child would be.
Back
They
then,
came
yeah.
they came back about 3 hours later, 10% uh, on the tow truck company, 2.5 million. So the same outcome of $250,000, but they were able to get that ninth vote by upping the non-economics and reducing the percentages of fault. Prop 51 was only 6 years old at the time.
Yeah.
Uh, so that introduced me to the intensity and stress, and how each trial, in order to prevail, which you don't always do, you have to believe. You have to believe. And then if you lose, you carve a little piece of yourself out. And win or lose, you give something of yourself. And so then we fast forward to that trial you mentioned that I just finished in September. That was 10 weeks. And I represented a 26-year-old quadriplegic in a case against Yamaha and their machine of appellate lawyer there every day, and sort of a bottomless pit of defense, and with stakes that were as high as any of any case that I've tried, longer than any case that I had tried, and carved more out of me than any case that I've ever tried. And
Yeah.
and sort of the bookend of that, where some things that happened in that trial where I had to call on all those intervening years of experience, where, helped me in tough times, during that trial, which had ups and downs. Um, I'll never forget that either. And the team that we sort of assembled, the group of lawyers that we had, who worked synergistically. I mean, I was sort of on my own in that one in 92, and it was a collaboration in this one that had real synergy and power, as a result, that no egos, just collaboration and ideas and listening and adapting and listening and listening and listening. So those would be the two, I think.
Those are great examples. Well, let me ask you a couple things about those comments. I mean, one thing is um, both of those examples are a great example of the difference that you can make as a trial lawyer for your client. And isn't that something that's really special?
Yeah, it's everything actually. And I think that defense attorneys, I have come to learn, feel the exact same way.
They
Uh,
do.
and even if it's a corporation, there's a person there, but especially when it's a homeowner or a driver or
Right.
some guy who works for FedEx and but oh my gosh, yes. That they have trusted you to do this form of justice for them and then for it to succeed. And you have contributed to palpably making Justin Van Tussenbrook's life better in this most recent verdict. And by maybe, the compensation was something for Bill Quackenbush, but having his day in court and having a jury say you were
Yep.
right
Yep.
um, meant way more to him. And
Yeah.
knowing that when they see us in trial, they see that we are bleeding for them. That has to feel good. I know it feels good for me to do that for them. I can't do anything. I mean, listen, I hooked up a VCR to itself and expected it to work. I have no lane other than maybe this in an effort to help people, combined with the philosophy that I'm not better or worse than anybody, and I treat everybody the same. And kindness is maybe the most important thing
Well, so
of
I
all.
think one of the great things that we get as trial lawyers is we get to the opportunity, also the heavy burden of responsibility of trying to make a difference in our client's life.
Yep.
And
It's
that's really better compensation, I think, than all the dollars. And the dollars are good, but I think that difference is a huge compensation for the
yeah, and it's what almost broke me. It just kept me up at night so much, especially when you have that inevitable bad day. And
yeah,
I do tend to try cases on the and count days. I mean, it's all about jury selection, but beyond that,
yeah.
um, I want to have more good days than they have. Meaning I got to have, it's like home team versus away. You should win at home. It shouldn't have too many bad days in your case, but you want to plug away and get some good days in their case.
Yep.
And I kind of look at it that way.
Exactly right. The other thing that you were mentioning, and it is so very true, is you give a part of yourself in every case, and the longer the case is, the more of you that gets given.
Yeah.
But something is taken out every case, and when you win, you're happy, but also when you lose, you're just crushed because you believed in that case so much.
Yeah. I had no bags before I started practicing law. I'm wearing glasses now because they tend to drip below them. But yeah, it ages you. But it's it's Teddy Roosevelt, right? You're in the arena. And
Absolutely.
I like that. And I've always liked that. Um, that's my it's not just my bliss, but it's my testing of my willingness to do the uncomfortable.
Yep. Yep. Well, thanks for those examples. And one of
Sure.
the things that I do in this is I only talk with people who are members of ABOTA. And I thought I would ask you this next. And why is ABOTA important to you?
It's funny because you mentioned various groups that I belong to, and I do, and it's nice and all that stuff. But there isn't one, in my view, besides ABOTA, whose mission is more devoted toward the Seventh Amendment and making sure that the jury trial lasts and
Yep.
endures. And so as I've gotten older and I've, been parts of committees of all of them, etc. I sort of had to make a choice. What's going to get the most bang for your buck and your bliss, your passion, which is trying cases and seeing other people try cases. And it was for sure ABOTA. And that wasn't even true when I was president. That's become more true post-COVID, where I thought as I, was getting into my 60s at 2020 at 60, you're either going to be part of the solution or going to be part of the problem. And there was this sense of, well, we can do this all by Zoom, and then pretty soon, do we really need to do this? And yes, we do. And so it has been the thing I've been doing with ABOTA ever since. That's all I focus on, such that we did things this year at our chapter that we hadn't done before with respect to doing flash trials instead of an MIT, so that we actually, and this comes from teaching at NITA as long as I have. The best way to teach is to have people learn by doing, by
Right.
getting them on their feet. And you're not on your feet when you're sitting watching an MIT. No disparaging of that as a concept, because you get to see great trials lawyers do their thing. But I just find it much more important for people to actually stand up and feel nervous and mess up and as you know, experience that high that comes from not necessarily a job well done, but a pat on the back that you stood up and you put two words together while you were on your feet in a persuasive way, while you were thinking on your feet, and you just feel great.
Right.
And that's what always happens. And if you can inject that feeling into people, they're going to be more inclined to try cases because they're going to want to chase that feeling. So that's why with ABOTA, Craig Peters and I ran this flash trials thing. It was an inaugural program. And then I sort of wormed my way into the National Trial College several years back. And then this year, co-chaired with Bill Shapiro, the inaugural advanced trial program. And next year, we're going to do the sort of regular trial program, and we're going to have a ton of people who are going to want to do it because I think there's some momentum building, and that's what I want to keep doing. That is both in the firm and out of the firm, my raison d'etre these days.
Well, that's great. That's great. So now when you're getting ready for these trials, and that last trial you were describing, it was a long trial, maybe the longest in your experience, but how do you get ready when you finally know, okay, this one is going to trial? And what's your process? How do you get ready to go so you're ready to go when the judge says, let's bring in a jury?
There's sort of a couple answers to that. When the judge said, let's get ready to go, let's bring in the jury, that means being prepared with the stuff, knowing your local rules and knowing what she's going to want. Your motions in limine, your list of witnesses, your exhibits, your voir dire, your questionnaire, all the shit, pardon me, all the stuff that you're gonna need to file. And
Yep.
you want to file it just like she wants it, so that you go in looking professional and ready to go. And that's a group effort.
Right.
If you have the luxury of having a few people help, that's important. But in the practical sense of getting ready for trial, there's two things that sort of jump out at me. One, I do a good facts, bad facts analysis, and I have my closing argument essentially written before anybody's doing an opening statement. Because if it isn't going into your closing argument, it's not going into the trial, is sort of the way I look at it. And so then you know where you need to go. So it's like writing the last chapter of the book, and then you get there.
Yep.
That begins with developing your theories and a theme that you're going to stick to. The thing that is more important to me, though, that I do in every trial is I practice jury selection. I never try cases without practicing jury selection. And people talk about opening statements and rehearsing it and all that stuff. And I believe in that. But if you're going to rehearse your opening statement, and you're going to be asking questions that are sometimes hard to get out because, I'm not alone in that my philosophy in jury selection is I want to empty my worry basket. That's the
Yep.
way I look at jury selection is
Yep.
what am I concerned about? My mini opening is going to highlight those things that I'm concerned about, wrapped in why we win. Parenthetically, I'm going to make sure an associate who doesn't have enough ABOTA points or many is going to give the mini opening so that they can get ABOTA points, and I'm going to make sure they put on a witness so that they can get ABOTA points.
That's
And
great.
and so I work with them on their mini opening, which I'm not saying you want to lose it, but you're not there to win it. And I think too many defense attorneys take their opening statement and shove it into 3 minutes and don't appreciate its purpose. And then I will practice jury selection with 10 people, 12 people, informally, inexpensively, sometimes in a more fancy pants focus group, sometimes not, just so I can blah, 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 say the words about the issues that are unique to this particular case. And I practice listening because my goal is to do about 10% of the talking.
Yeah.
And so that's the most important part of the trial, as far as I'm concerned, and the part that I devote the most attention, well, yeah, you could say the most attention to. Uh, so that's a big part of, in my view, my pretrial prep is what,
Preparation.
yeah.
In
Um,
these practice sessions, no matter how many people you have or how formal or informal it is, are you actually going through with this group of people and taking what, half an hour or 15 minutes?
hour and a half.
Okay.
Yeah,
You're really covering a lot of things, much maybe more than the judge would let you cover in the courtroom, but you want to just get practice asking lots of questions.
yeah. One of the hardest things is the first 3 minutes.
Yeah,
And we don't try, I'm supposed to start a trial on November 2nd. I tried this case. I think I picked the jury at the end of, the late of July. It had been a year since I'd picked the jury before that. And time goes. And when I was a deputy DA, I think I tried 18 cases in 3 years. So you're just going kind of back to back to back. That's just not the way it is here. So you,
right.
you sometimes just gotta, you have the muscle memory, but it's good to loosen it up. And it gives you confidence going into actual jury selection. So even if you're going to be more than, a judge might give you 45 minutes or something, or
Right.
an hour at the most, or um, yeah, just talking about it and hearing things and practicing how you say things, active listening, bouncing ideas off of, and then um, converting your questions from open-ended to leading to get your cause challenges and even your physical movement when you're getting cause challenges and how
Yeah.
what I'm saying, you're being less confrontational, but your words are confrontational. So we can agree in a folksy way that, at least with respect to this, it's hard for you to be entirely impartial, as opposed to, and you can't be impartial about this, can you? I mean, you're much more likely to say yes to the former than the latter, but the words mean the same either way. And if you can, and entire impartiality are buzzwords under the civil code for purposes of express bias. So um, I just find that the more you can sort of do that ahead of time, every cause challenge you get, you've saved a peremptory, you've made a difference. Um,
Big difference. Yeah.
so
Now,
so
now, when you get a juror in the courtroom and you think there may be a challenge for cause, the way your conversation is going, you know darn well that even if you get them all the way down at the end, the judge is going to try to rehabilitate them and try to keep them from going out for cause. So, what do you do to try to seal that door shut?
Well, first of all, I can't remember the name of the case. I think it's Lombardi, and it's from 1899, and it stands for the proposition that you cannot rehabilitate someone who has admitted to that they're biased or that they
Right.
can't be impartial. Um, and so with a brief, we educate judges with respect to that. We also, I think, you go in with a certain sense of credibility by being prepared, by
Yep.
not wasting time, by getting to the point, and then earning a little bit of the respect of the judge that you're not wasting time and that they will, give you a little bit of a break. Um, and I have found that most judges are pretty good with cause challenges. They take it seriously as they should because they want a fair jury.
They
Um,
should.
yeah, and so my experience has been, now that you mention it, that fewer judges than used to be are intent on that rehabilitation. If you're sitting there with nobody in the veneer and you've got five challenges and there's four people left, and I think I could see a judge going, I'm not going to give you that one, to force you to do it. But
Right.
I think that the notion is be crystal clear in your questions, get answers that say, I cannot be partial. I am not entirely impartial. This is not the right case for me. I'm not an unfair person, but I
Right.
have this bias and I can't overcome it. I don't care what judge you are. You should not let that person stay on.
I agree with you. But
Yeah,
yeah, that's a positive trend that judges are less likely to try to rehabilitate than maybe early in the days when you were trying cases.
I think
So the
that's right.
most important part of the trial for you is picking the jury, the voir dire. Um, and in the mini opening, which you only have a few minutes to give, you're really trying to get out some of the bad stuff to then get you set up, I take it, for the questions on voir dire.
Yeah, motorcycle, not wearing a helmet, alcohol, speed. Um, you're not sitting there going, my case sucks. He passed on the right. He was going too fast. I mean, but it is wending its way through such that you can say, remember in the mini opening that we talked to you about the fact that Mr. So-and-so was riding a motorcycle.
Right.
I want to talk to you about that and people's feelings because there's a lot of people who think that if you get on a motorcycle, you're nuts. And no matter what happens, you assume that risk. How many of you feel that way? And you'll get 10 hands. And to
Yep.
me, that's gold. The more of that you can get, the better. Because what I have found is when you get that poison out, there's no such thing as poisoning a jury. You get that poison out, two things happen. One, you really have an opportunity to get real cause challenges.
Yep.
Two, I tend to try to make it sound worse and again, when I say I mean I practice what other people have taught me. I didn't invent any of this stuff, but I do try to make it seem worse in jury selection than it is in reality. Not by being disingenuous or lying or anything like that, but motorcycle, 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 you are lucky enough to represent a non-lane splitting, leather wearing, law abiding, safe motorcyclist. We don't talk about that during jury selection.
Right.
So that when they hear it, they're like, oh. So not only do you get some cause challenges, but, and this is only tangentially on that last point, when you've talked about the poison so much, the poison doesn't seem as bad, even if it's the same poison,
Right.
because it's all been talked about. Um, so that'd be like ignoring it on opening statement, your bad facts, because and then letting the defense say it for the first time.
Yeah,
Um,
you don't want that. And not only does it make it sound less bad, but don't you think it helps your credibility with the jury?
I think so. And let me give you an example. And I don't the guy I tried the case against, the two lawyers in this last case, really good lawyers, some of the best lawyers I've ever tried a case against. But I found it interesting, and I should talk to them at some point. During their jury selection, there were other similar incidents in my case that were very helpful. In fact, it's a rollover on a sand dune in Utah. Talk about assumption of the risk, and yet we argued that the roof was defective and there had been other complaints by customers about how easily the roof folded. And there was maybe 8 other similar incidents we were going to get in, and then 8 other lawsuits that we were
Wow.
going to be able to get in. So there's a lot of other similar incidents, and I think that's what really helped us prevail. Never mentioned in jury selection, ever by the defense. The first time the juries
Never.
heard, never.
That was like a gift to you guys.
The first time the jury heard about other similar incidents in the case, because we weren't going to mention it, because that's favorable stuff for us. Why would we talk about it? Was in
Right.
our opening statement.
Yeah.
And um, listen, it was a case that I thought up until the jury asked a question about damages that we could very, very well lose. In fact, the first question they asked, I thought, okay, we're going to lose based on the question, which goes to show don't believe the questions all the time.
Yeah.
But I thought that was interesting, not to want to say, even in the mini opening, there have been other incidents, and how many of you believe that if they're, just not judging this case, but whatever you would ask, but it wasn't.
Yeah. Interesting. Interesting. Now, you've tried some cases since we've come out of the COVID shutdown and all that. Do you think jurors are acting differently since we've come out of shutdown, or do you think they're still acting pretty much the same in the different places you try cases?
I think overall verdicts and settlements have increased since COVID, and I know I'm not alone in that. So I do think there has been an uptick to the point where I think, the adage pigs get fat, hogs get slaughtered. I think that we have to be careful about that. Um, but I do think that there have been more bigger verdicts. But I think I don't know if that's because of COVID and the amounts of money that were thrown around about like the PPP or whatever, and I don't know. I don't know. But
Well,
there's also plenty of defense verdicts.
you don't have to have a theory, but you just had this experience of you think there's some difference.
I do. I
Yeah.
do. Yeah, and I don't particularly have a theory, but
Yeah, I think
that's
there are a lot of different theories people have. Well, let me ask you this. Rich, you're only going to go to trial in your cases, and your cases are big cases. There's big damages, uh, serious injuries, those kinds of things. And one of the things you have to get out, and I'm sure you're going to be doing this as part of picking your jury, but you got to get out the fact that you're dealing with big damages and you got to get something before the jury to see what their reaction is. How early do you bring out this concept of how big the damages are and how do you express it initially, whether it's a range or other ways?
capital EARLY, early. And so in the mini opening, I mean, talk about a worry basket. That's the biggest item on the worry basket,
Hmm.
it seems to me, um, because especially non-economic damages.
Right.
Um, and so we talk about it and we talk about it in specifics. We're going to be seeking compensation in more than a couple $1 million a year. for the rest of his life, kind of thing.
Yeah,
Um,
that kind of thing.
yep. And
Okay.
then I like to ask every juror about the concept of uh, pain and suffering, physical impairment, loss of enjoyment of life, all of those features of non-economic damages during jury selection. Again, just like motorcycles, so that when they hear numbers and in opening statement, they're going to hear it again. They're
Yep.
not sitting there going, "What?" I mean, the last thing I want to do is surprise them and cause them to be so off-put by it. And this is, again, part of jury selection and making jurors feel safe about their ability to be honest uh, by rewarding candor, by listening and rewarding candor, as opposed to challenging. You know what I
So
mean?
how do you reward candor in the courtroom?
So, first of all, I tell them, I'll say something like, my uh, bags under my eyes may be fleshy, but my skin is thick. I think I've said that once, maybe never again. But I'll say I can take it. Some of you people might not even believe that lawsuits should ever be brought. And let me know. Let me have it. You're not going to hurt my feelings. It's really important. Okay, so you can say that at the beginning, and everybody says that, and they do the cherry pie thing or whatever they want to do. But you have to mean it. And there's a lot of people who will say it and then not appreciate that there are opportunities. Uh, it's an EQ thing. It's like, well, when my husband died, I did this, and then I decided to get a motorcycle. What kind of motorcycle did you get? As opposed to, I am so sorry to hear about your husband. You know what I
Yeah.
mean? I mean, there's just there are people who will just go, okay, what kind, what? I mean, be freaking human.
Yeah.
And so then when they will give you an answer, which is, I actually don't believe, I believe in medical bills, believe earnings loss. I do not think that anyone should be entitled to that um, for any kind of non-economic damages, as you put it, lawyer. And then I will say, this is exactly what I was talking about earlier. That's not what other people said here. It's how you feel, and you felt comfortable telling me that, and I can't tell you how much I appreciate that, because that's what this is about, is finding out how you feel. And so thank you for doing that, first of all. Secondly, that's not something that you just thought of today, right? I mean, you felt that for a while. It's a firmly held belief. I'm not talking you out of that, true? Nor is Her Honor. And we were at a cocktail party. That's how you'd be feeling. I mean, that's just how you feel, and that's how you felt for a long time. Yeah. So in a case where we're asking for compensation for non-economic damages, especially the amounts we're talking about, kind of not the right case for you, right? I mean, it's hard for you to be entirely impartial when you feel that way. Yes. So then that feels like a non-offensive way of, now I just got a cause challenge. But then juror number 8 looks at that and goes, okay, well, he's not an ass, and I actually can believe him. And the truth of the matter is, because I mean it. You know what I mean? And
Right.
if you mean it, then that's 99% of this. Is be genuine, be real, be human.
Right. And they know that.
Yeah,
They know that and they get it. And yeah, you got to make them feel comfortable with just being honest with you.
yeah,
So, and it's okay if this isn't the right case for them. They might be a great juror on some other case.
exactly,
Yeah. You
exactly.
you just got to make sure you got the right jurors for this case
Yeah.
and, what they have to decide and all that. Well, when you're getting into your opening statement, you've gotten your jury. Hopefully, you got a good jury. You like the jurors you picked, and that's worked well. So, how do you go about telling your story in your opening statement? You already said you started with a closing argument and you know what you're going to talk about, but how do you go first telling them the story and they haven't heard this before?
So I tend to begin with a grabber, a theme. This is a case about a rollover protective structure that doesn't protect in a forward rollover, like a life vest that sinks, a smoke detector that doesn't go off when there's smoke.
Yep.
Um, Now, those two sentences are argumentative, but you can get away with it in the first 30 seconds of your close. I mean, your
Yep.
opening.
Opening. Yep.
But then the most important thing for my money with an opening statement is to tell a story, and that for me, and this is something born in experience, my lens is always on the defense. So if I am filming this story, I am starting with the defense. Because my favorite, and now I've used it 5 times, including in this trial, because so often cases involve apportionment of fault
Yep. They do.
between either your client or between an insolvent somebody and the target defendant.
Yep.
And so years ago, and I am answering your question, I promise, I was trying to figure out how do I explain to a jury in closing argument how to apportion fault in this case. And I was driving by a school that did a school fundraiser with those thermometers. And it was, 3/4 filled. And there's a goal amount, right? And it's 80% of the goal. And I thought, what if that thermometer, instead of being filled with money, were filled with fault? And I write fault, and it's low tech, it's on butcher paper. I write
Yep.
fault next to the thermometer, and it's an empty thermometer, long neck with the bulb at the bottom, and then a lip at the top. And right near the top of the lip is the date of the incident. So what I do in closing argument when I'm talking apportionment is I've got a big, thick red felt pen, and I've already talked about all their fault. But then in a truncated fashion, I fill the thermometer with all the fault until we get to the day of the accident. And I say there's 100% of fault in this thermometer. And by the time we get to August 30, 2020, which was our case,
Yep.
the thermometer is 90% full of their fault. Now, that fault began with their design back in 2014.
Yeah. Way back.
So that's where my opening statement is telling the story of those failures from way back then. The single point of failure is back in time. Again, this isn't, me. This is just executing it. And so I think of it in those terms. We don't even get to my client. This is sort of David Ballian.
Yeah.
We don't even get to our client. So I'm telling the story with the lens on them in a way that proves that they were at fault and does a lot of explaining of what things are and what things matter, etc. Then about 2/3 of the way through, my weaknesses are right there. What you're going to hear or what we wanted to know or what we had to decide were X, Y, and Z. He wasn't wearing a helmet, but did it matter? Those kinds of things.
Right.
Because again, I don't want them hearing that for the first time, but I don't want to make it primary or recent, right?
Right.
And so it's wedged, and then we go to damages. And then I finish with what we want, and I try to be symmetrical with the theme. So that's kind of the opening.
Okay. That's your opening statement. So you've gotten your jury, you've told your story. You're now going into the case and in trial in terms of
And
presenting
let me
the
just
case.
interrupt, Monty, to say lots of demonstratives
Yep. In the opening.
and try to do it in the present tense.
Yeah.
Anyway,
Okay.
keep going.
Now that you're starting to present your case and you're doing your direct and cross and all that, let's talk about cross for a little bit. And that is, I think of cross examination as there may be more than two the way I think of it, but I think of it as two basic types of cross. One is the classic closed cross that everybody is taught in law school, and most people do their cross that way. But then I would call what I would call open cross as kind of a Jerry Spence. There's a guy in San Diego who's passed away recently who was a brilliant guy named Milt Silverman. They would do these unbelievable open crosses. And they're really, it's like they don't care what the witness says. They just are telling their story with their cross. How do you cross? And do you use different approaches with different kinds of people or different situations?
I don't consider myself, and this isn't false modesty, this is just true, a natural when it comes to any trial work. But
Mhm.
I think I'm good with people. But when it comes to the brilliance or of a Jerry Spence or a Nick Rowley or all those
Yeah,
guys,
all those guys.
yeah, I'm not that guy. But I like being creative. But I do get a little fundamental with respect to cross in that as hard as it can be, I want to start strong and end strong. So that
Yes.
my sit down line is going to be my second best or first or best point.
Yep.
Um, number one. Number two, um, I do try to be a one fact per question, short question person to build a point. I've got a certain number of points I want to make. I think of cross-examination's purpose as twofold. One, if you ever ask a cross-examination question that begins with so, that's the conclusion. I want to do that in my closing argument. So my purpose of my cross is to build blocks for my so in closing argument. Because I don't want to ask so on cross because they'll say, no, I don't think so. I'd rather say, do my conclusion based upon what I got for close. The second is to impeach their credibility.
Yep.
So to me, it's build blocks for close. If it doesn't inform your closing argument, then don't ask it. And assail their credibility. If they give you the beauty of you're marching down your line of the points you want to make, they give you an inconsistent statement. You go off the track and shove that up their keister and then come back and keep going. Thank you. So I love that. I never, when I'm impeaching a witness with prior inconsistent statement, say anything other than I read that correctly, didn't I? Because in California, under 1235, an inconsistent statement is an exception to the hearsay rule. It's evidence
Yep.
that I get to read
Yep.
and I get to look at the jury. And I act fair by giving him or her the transcript. But the only question I ask them is, I read that correctly, didn't I? Boom. So the open-ended stuff, I will ask. I feel like you should have tried 10 or 15 cases before you get into the world of open-ended questions on cross.
I
Because
agree with you.
you have to know what question you don't care what the answer is.
Right.
And when I have stuff where I don't care what the answer is, I will ask open-ended questions and I love it. Tell us why you decided not to do that.
Yeah, I think that the old adage that everybody's taught in law school of don't ask a question you don't know the answer. That's right most of the time.
Right.
But I think if you really know your case, whether it's 1% or 5%, there are some times where they don't have any good answer, and you should ask the question then.
The only exception would be control is such an important part of cross.
Yes.
And if you have just a runaway witness and then you're asking open-ended questions, you're sending her or him a message. You can say whatever the hell you want. So I think it just has to be, listen, it's a game time feel.
Yep. Yep. And you only know it when you're in the arena at that
Yeah.
moment.
Yeah.
Only know it. Well, when you're now when you've presented your evidence and now you're going to make your final argument, So now you've written that way back, but what is your strategy in your final argument? And also, as part of that final argument, what things are you telling or tools are you giving to the jury to help them figure out how to put dollars on non-economic damages?
So, with respect to the close, I have a bit of a prescription of how it looks generally. And two things that I've learned to do toward the beginning after thanking them sincerely for the importance of what they're about to do and their sacrifice. Like I said, this last trial was 9 weeks. Um, is let them know about the burden of proof and comparing it to beyond a reasonable doubt. That I always say in the reason for the difference is because in that case, the door locks from the outside, the prison cell. Um, and so someone's freezing at stake. But the other thing that I like to say is it only takes 9 of you for each one. You're going to hear her instruction on this. There may be some flat earthers. There may be people that believe there was no moon landing. It doesn't stall you, and it doesn't have to be the same 9. I think those are sort of liberating things.
Yes.
Um, then I'm offensively focused on the defense using their own evidence. Then I typically talk about, and I'm jury instructions, special verdict form in real, not on a PowerPoint,
Yep.
marketing. Um,
Marking.
then I talk a lot about credibility, and the two analogies that I tend to use with credibility are, and I guess I'll just say my favorite one is because I never want to call somebody a liar because there's no burden to call them a liar. But I'll say that, what he or she is saying or what they're saying or what the defense is like trying to put a queen size sheet on a king size bed. You get one corner down and you get a second corner down, and you might even get that third corner down. But when you go to the fourth, the first one pops up and it drives you crazy because it doesn't fit. And neither does that version of events. And
Yeah.
so then I'll launch into credibility issues with respect to that. And I always have fun with that. And then with damages, it was actually Bill Veen um, and Craig and Cynthia McGuinn at Veen's office. They have this pie chart that has pieces of loss of enjoyment of life, grief and sorrow, physical impairment, pain, those kinds of things. And what I have used is this pie chart, and then one of the pies pops out, and then you've got all the photos and the diagnostics and the testimony that inform each of those. When you have begun the concept of non-economic damages from mini opening to opening statement to paying attention to it in opening statement and not just giving it lip service, and then focusing on it in your case in chief without going over the top, without being repetitive,
Yep.
which I think is important. I think you're sort of paved the way so that I have a chart, and Craig is actually the one who used this, which sort of has a bar chart for each year of that amount of money that you've been asking for. And I think you have to be, we used to, Mike and I tried a couple cases, Mike Kelly, where it was the job interview, wanted,
Right.
someone who this. That's a bit of that's a little bit fraught. You have to be careful about that as straying a little into the golden rule. And so I'm a little bit reticent to use that. I found that really effective. But these cases that we have, as you said, they're usually catastrophic. The damages tend to speak for themselves.
Yep.
And I like to imbue within the jury their hundreds of years of experience to do the right thing and make suggestions that that make sense and are reasonable and just. I have used in wrongful death cases, the amount of money people will take to save lives, how much money we will spend to save pilots who have and Rembrandt costs and half justice versus full justice. And the Brian Panish, I saw an argument of his once that I really liked, that there's a whole aisle in every pharmacy devoted to pain, for pain relief for a
Yeah.
reason, So I mean, there's a ton of arguments, and I'm not particularly great at any particular one of them, but it's one of those things where I have to mean it. I'm more conservative in my mind with respect to damages. So I have to mean it. I tell them exactly what I think the number should be. I will sometimes even write it down on the verdict. Sometimes I will say, this is just my recommendation. This is borne out by the evidence. You will do the right thing. It sort of goes from case to case and depends on the client
Right.
and how the case went in.
And yeah, how the case came in. Yeah. How you feel about it. Well, that's great. Thank you for sharing that. And I want to go to one thing before we're going to end in a couple of minutes, but there's something that I wanted to ask you about, and that is in California, we have this thing we call the expedited jury trial, and you've had some involvement with that with some other people, but do you think that the expedited jury trial, where you try the case faster with fewer jurors, is something that can be helpful? And how can it help in the giving of opportunities to learn how to try cases to younger lawyers, but can it also be useful for trials and maybe other cases that aren't even part of the statute, because it's usually a small auto PI kind of a case? What are your thoughts on expedited jury trials?
Well, first of all, it doesn't have to be a small case, as you said. It
Yeah,
can be a one-issue deal that the lawyers really want to figure out.
right.
But if you asked me this question 2 years ago, I would have proudly told you, maybe even a year ago, but more like 1 to 2 years ago, that I was on an expedited jury trial high horse. Have been for years, such that I met with almost all the presiding judges in the Bay Area wearing my ABOTA hat, and was successful in getting San Francisco Superior Court and Alameda Superior Court, the two biggest courthouses, to change and add expedited jury trial as a potential to their materials that they provide with the filing of a complaint, because
Mm,
of how strongly I believe in that. I have tried with the Judicial Council to get the case management conference statement to have as an option expedited jury trial instead of arbitration. It
yeah.
says arbitration, so that's antiquated. But in the last year, I haven't been working on it as much. We were making progress of maybe getting a dedicated expedited jury trial judge in Alameda County and San Francisco
Wow.
to try those cases, because I think you're right. It's a great way to get people with trial experience. The biggest stumbling block, and where things kind of slow down, and I'd like to rev them back up, but I've been so busy with trials, is with the insurance companies and their willingness to allow this to happen. There can be high lows with these. So there's
Yeah,
protection.
right.
And you know as well as I do, the civil defense bar, the lawyers our age, the Chris Beemans whom you've interviewed, and the other just terrific civil defense attorneys, both med mal and non-med mal, are sitting there going, they want us to try all the cases. There are lawyers, we're not going to be here forever. And so I think there should be incentives on the insurance companies to say, okay, let's at least do these relatively harmless as far as our exposure. We'll condition it upon there being a high low. We're going to spend less money. I want
Yeah.
to give our lawyers trial experience for the big cases. I'm just all for it. In fact, I've talked to Mike McGuire, who you know well,
Yeah.
who's a huge proponent of it. Eric Trout is a huge proponent of it. Um, and I think that, if we can get this sort of flash trial thing up and running, which I'd like to see happen in all over the place, I'm going to turn my attention back to that.
Well, that's great. Your flash trial idea is great too, because I think you have to give the student the experience. I agree with you 100% on
Yeah,
that. And
yeah.
uh, and that's great. Well, I tell you, Rich, this discussion goes so fast. It's so much fun to talk about
I
this.
know.
It's been wonderful, but I'm going to have to get us here to the finish line, and I want to finish off with this. You've been a successful trial lawyer for many years, and there is a need for younger lawyers to learn how to try cases. What advice would you give to younger people who want to become a trial lawyer, whether they're just starting out or they've tried a couple of cases? Maybe it's advice you were given when you were younger. Maybe it's things you've learned. Maybe it's a combination of both. What advice do you have to give?
So, especially for the young lawyers or law students, um, I'm a huge believer in going to a public entity and trying cases, either for defense or prosecutor.
Yeah.
Um, I think it's a great fertile ground for learning, for cutting your teeth on trying cases. It worked beautifully for me. I felt so comfortable coming out of there, being in the courtroom with lawyers who were 20 years my senior and hadn't tried as many cases. So there is something about giving you the confidence to do that. Um, I think being fearless and not getting sucked into just settling cases, but trying some cases and not being afraid to lose. Um, somebody's got to lose. And so long as you believe in your case, and you're honest and you do it with integrity, uh, good for you for doing it. Seek out people and go to work for people who have the illness of needing to try cases. I never was in the I want to try cases. I was in the my life. I'm either going to be an actor, but I have a face for radio, or I'm going to I'm going to try cases because that's my that lane I have. And so it was never a want, it was a need, it was a passion. And
Yeah.
if you have it, don't let it go. Don't let it go. And find someone who shares it. There's a lot of people who share it, who feel it, and hook yourself up in a non the way the kids use it today way.
That's all great advice. And thanks for sharing that advice, Rich. And also, thanks for all the good that you do with your work with ABOTA, all the great work you do with your clients. And thanks for being a guest on the show today. It's been really great talking to you.
Monty, what a pleasure. Thank you for all you do and for doing this. And for the six of you who watch this because of me, I want to say hello.
Okay, that's it for today. And until the next episode, do well and be well. Bye bye now.